welcome back to Legal Empowerment through Interaction Lecture Series. It's indeed a privilege to welcome you all in the new year to the 286th session of Letils. It's nice to be back, and what better way to start the new year than to have our own family member, an expert on the subject, Justice Somayajulu sir, who now is a senior advocate of the Supreme Court. And to introduce the subject, we have another senior advocate, a good friend of ours, Sri Guru Krishnakumar. And we are privileged with the presence of Justice Ramkumar and Justice Ramakrishnan, and all of you, the family members in this journey of empowerment, interaction, enlightenment. It has been a pleasure to be with you. After a brief break, after the 285th session, we are back in the 286th session. And today it is even more, we are even more happier and even, in fact, proud because Panamanga family member Vijay is now to be addressed as Honorable Mr. Justice Vijay. He is here. Vijay, can we have a few words from you before we start the function, please? Please.
Thank you, Shyam. Well, it's been, I don't know what to say. You're taking me by surprise. I was here to listen. I'm tuned to listen also from now on. So I'm eager to hear Justice Somayajulu sir address the gathering on the subject, which is quite new to me. So I'm here to listen, and it's always been a learning whenever there has been a lecture on this platform for me. And so to many others. I'm sure this will go on for more regularly from now on. Thank you.
Thank you very much. And
no agony to be shared. No agony on the bench to be shared.
He just fresh on the bench, sir. Give him some more time.
No, not on this platform, sir.
Good. That shift is working.
Thank you, sir. And sitting in this part of the country, in the largest democracy and the most successfully working democracy, the topic is of much importance. And without wasting any time, may I request Senior Advocate Sri Guru Krishnakumar sir to do the introductory remarks. Please, sir.
Very good evening and happy new year to everyone present here today. Many familiar faces, few not so familiar faces, but it's always a pleasure to be back with this group. And before I give my introductory remarks on the topic itself, a couple of other mundane things, if I may call it so. My attire is in no manner to intrude into the informality of this group or of this platform. Only a coincidence, because it so happened that I was addressing another seminar in person just a while ago, and I just walked into my office after attending that. Having been a speaker in person there, it had to be a little more formal. And of course, it's also coupled with the fact that geographically I'm placed in Delhi, which is definitely not very warm. I'm talking only in terms of temperature. So that's really the reason and the cause for my countenance today in a jacket, as distinguished from everybody else in their informal attire or not so formal attire. Now, talking of introductory remarks, I'm reminded of a vote of thanks. It would sound a little anomalous that I'm talking about a vote of thanks when I'm asked to give an introductory remark. One of the shortest vote of thanks that I came across was by a person who, after a very long meeting, said only this: I thank everyone who had anything to do with the program today, and finished it. It was such a relief for everybody. And today what I'm looking at is the obverse of that. I want to give an introductory remark which is not very long, because that would mean that I'm going to stand in the way of a very erudite presentation on the subject by Justice Somayajulu. Therefore, I will try to... So, sorry?
No, it's okay.
I think someone is having their mic on, I think.
No, it's okay, sir. Good minutes.
Yeah. So let me try to be as brief as possible by just giving a flavor, as it were, of the topic. In fact, talking of brevity, one other interesting incident. A speaker was asked to speak on the subject paper. So everybody spoke about paper, how it is valuable and how it is made, how nature is destroyed, etc., etc., and how they said how thoughts are penned in paper, etc., etc. One speaker just fished out, when his turn came, from his pocket a few currency notes and just tore them up and said pieces of paper. So let me see what amount of brevity I can bring into the introductory remark. Now the topic is a critique on the High Court and election petitions in the context of interface of law and politics. As I see it, it throws up several interesting ponderables. Now, the scheme of the law itself is a little convoluted. You start with the Constitution. Constitution under Article 102 and 190 deal with disqualification of membership of the parliament or a state legislature, as the case may be. Now that sets out several grounds. And one of them finally is how it says, to just take the language itself, you take 190, for example, that talks of how under 191 1D or E, if a person is so disqualified by or under any law made by parliament. Now that takes us to the Representation of People Act. We of course have the Representation of People Act of 1950 and the Representation of People Act of 1951. We are concerned with the provisions of the Representation of People Act 1951 when we deal with election petitions and the high courts, because section 100 deals with grounds for declaring an election to be void. This is of course apart from the fact that chapter 2 of the RP Act 1951, it talks about how election petitions shall be filed in accordance with the procedure of the act, and how the High Court under 80 capital A will try. Originally, we go back to days of N.P. Ponuswamy and all those cases. We initially had election tribunals, then the election commission dealing with certain types of disputes, and ultimately jurisdiction vesting in the High Court, if I remember right, sometime in 1966. Now, this is so far as the procedure is concerned. What I'm really wanting to focus on is section 100. Now, section 100, if we look at, it talks about how, subject to the provisions of subsection 2, if the High Court is of the opinion, A, that on the date of his election, a returned candidate was not qualified or was disqualified to be chosen to fill the seat under the Constitution of India or the Government of Union Territories Act 1963. Now, that is a provision which is susceptible to objective standards, if I may say so, because there are enumerated standards. Then come to B, that any corrupt practice has been committed by a returned candidate or his election agent or by any other person with the consent of a returned candidate or his election agent. Now, so far as corrupt practice is concerned, again, there is some kind of a definitional attempt in the statute, because we have section 123, which deals with or which defines certain practices to be corrupt practices. To that extent also, perhaps we don't have much of ponderable or uncertainty. Then come to C, any nomination has been improperly rejected. Now, there again, one can reasonably proceed on the basis that it is not susceptible of too much of confusion, because there are provisions as to manner of consideration of nomination papers, scrutiny, acceptance, rejection, etc. There again, I suppose we can say that it is some kind of objective standard that we are looking at. Now comes D, which I think is a very, very tricky provision, that the result of the election, insofar as it concerns a returned candidate, has been materially affected, expression being materially affected. And subclause 1, by the improper acceptance of any nomination. Then subclause 2, it says by any corrupt practice committed in the interest of the returned candidate by an agent other than his election agent, or by the improper reception, refusal, or rejection of any vote, or the reception of any vote which is void, or by non-compliance with the provisions of the Constitution or of this Act, or of any rules or order made under this Act, the High Court shall declare the election of the returned candidate to be void. Now, what I wanted to really flag for the consideration of the group and today's discussion is this provision found in 101D subclause 1, improper acceptance of any nomination. Now, what are the circumstances under which it can be done? Let me give an example. This is one matter which I was involved in at some stage. Therefore, this example came to my mind immediately. Let's say there is a pre-poll alliance between 5 parties. There is a lead party, which is supposed to be the most popular amongst the electorate, amongst the 5 parties which have joined the alliance. And in this seat sharing that takes place prior to the holding of the elections, the parties agree that all the contestants in this pre-poll alliance, even though they may belong to various political parties, they will contest on the symbol of the lead political party, which is the leader of the alliance. Accordingly, a decision is taken, and a candidate belonging to X party, which is a member of the alliance, even though he is not a full member of the lead party, which is the Y party, he files his nomination papers on the symbol of the lead party. The question will come whether the nomination filed is right. Now, in fact, such an issue was raised in one matter. Now, 3 reasons why the court said this cannot be a case of improper acceptance of nomination. 1, the party to which the candidate originally belonged was not a recognized or a registered political party in the concerned state where the particular election was taking place. And therefore, there was no impediment for him to contest from the symbol of the other party to which he did not belong originally. Number 2, that party, because of the fact that it was not recognized, did not have a symbol allotted to it under the symbols order. Number 3, the party Y, which is the leader of the alliance, itself nominated this candidate as its nominee, as its candidate, by having the recognized signatories signing Form A and Form B, which are the forms necessary for valid nomination under the RP Act. Now, these were some of the reasons which were accepted by the court to say that it cannot be taken to be a case of improper acceptance of nomination. Now, the court also looked at one more aspect. The court looked at the fact that the lead party itself did not have a problem with another candidate belonging to another political party to be nominated as their candidate. And one more thing, the court looked at the fact that there was a pre-poll alliance, which was the basis for this kind of nomination. Now, please consider a situation where we don't have any of these qualifying factors. If that be so, will it then become a case of improper acceptance of nomination? What is the judicially ascertainable standard by which the High Court can decide either way? I think these are all some of the issues which arise for consideration while considering this topic. Then we have a host of other issues. We have section 77, which talks about election expenditure. Now, there is a cap on that. And as one would always see, promptly you have the exceptions to the law, where the exceptions always become the escape route for not complying with the law. You have the concept of star campaigners. You have the concept of lead party or political leaders whose expenses are not included. It's only the individual candidates who are required to give their expenses, or their agents who are required to account for their expenses. Then what about an alliance where this kind of a problem arises? So I think the law is so obtruse in that sense, and a High Court exercising jurisdiction in such matters is something where such ponderables arise and really throws up challenging situations. These are really 1 or 2 of the concepts that I wanted to flag. And I'm sure in the course of this presentation, Justice Somayajulu, with his vast experience, will place in perspective many of these and other issues. Thank you very much. It's always a pleasure to be part of this group, and I look forward to hearing Justice Somayajulu. Thank you.
Thank you very much, sir. now that the stage is set, we'll have the main actor and Somayajulu sir.
Thank you,
All
Shyam.
yours.
Kumar sir, Ramakrishnan sir, and Sri Krishnakumar sir. Thank you so much. Krishnakumar sir, thank you for setting the tone and the tenor of the meeting. Initially, I wanted to talk about election disputes and the High Court. Essentially, my emphasis was on the failure, according to me, of the High Court. I didn't want to use the word critique. But then, my good friend Shyam, I don't know how many of you remember the movie 10 Commandments, where Yul Brynner plays the Pharaoh. You know, he has this fantastic sentence, so shall it be written, so shall it be done. And nobody else can oppose it in the entire kingdom of Egypt, so is the situation with me. I did not want to use the word critique, but Shyam brought in the word critique, as a result of which now I am concentrating on what I feel is the failure of the system in this critical area. Vijay, since I'm no longer on that side of the bench, I can afford to say it. That is why I'm taking the liberty of saying it. In fact, the judgment of Justice Jasti Chalameshwar in Muhammad Jan's case is something that has been plaguing me for a long, long time. His Lordship said the whole system, it has become a mockery of justice. This whole concept of trial of election cases has become a mockery of justice. Very, very strong words used from the bench by His Lordship then. Since then, till date, this has been troubling me. And I'm sure as we go further, I don't know how many of you are going to agree with what I say. The point that Sri Krishnakumar raised, Guru Krishnakumar raised, is very, very pertinent. It starts with the Representation of People's Act itself and the Constitution of India. In fact, if we go into the Constitution of India, we will have to look into Article 329B, which says, except the High Court, nobody else can try a case relating to an election. Till 1966, as Mr. Guru Krishnakumar pointed out, we had election tribunals. These tribunals were dealing with these cases relating to the elections till then. By an amendment in 1966, the High Court was given the exclusive power to try election disputes pertaining to elections to legislatures and the parliament. Other articles, of course, are there relating to the panchayat, the municipality, that is Article 243O, 243ZG, etc. But if you look at 329G, you will find the words are very clear and very 329B. No election to either the House of Parliament or to either House of Legislature shall be called into question except by an election petition presented to such authority and in such manner. So the jurisdiction of every other court has been taken away. The representation of, I'm only trying to give you the legal backdrop and the vision that the founding fathers had in conferring this jurisdiction to the high courts, these tribunals, which is, and the ground reality as it exists today. Since at the end of the day, we will have to decide. I have come to my own conclusion. We will all have to conclude, decide whether there is a failure or not. If you look at 329, it is very clear. The language is peremptory. It's very clear. It says nobody else except the High Court. If you look at the Representation of People's Act, you will also notice that certain timelines were set, certain standards were set in the Act, and this is what the founding fathers wanted the election tribunals to actually follow. I'll just draw your attention to a few sections, not much. If you look at Section 80 of the Representation of People's Act 1951, as rightly pointed out by Sri Guru Krishnakumar, it says, no election shall be called into question except by an election petition presented in accordance with the Act. 329 of the Constitution of India, read with this, takes away the jurisdiction of every other court relating to an election dispute except the High Court. Section 80, Clause A, the court having jurisdiction to try an election petition shall be the High Court. Such jurisdiction shall be exercised ordinarily by a single judge of the High Court, and the Chief Justice shall from time to time assign one or more judges for that purpose. Then the next section that I would like to draw your attention to is section 86, clause 6 of the Representation of People's Act. Remember, ladies and gentlemen, we are dealing with an amendment of the year 1966, and we are discussing the topic in 2024. At the end of the day, we will all have to think whether this amendment and the purpose for which it has been introduced has actually been achieved or not. Now, if you kindly look at 86.6, 86 deals with the trial of election petitions. This is chapter 3 of the Representation of People's Act. The trial of an election petition shall, so far as it is practicable, consistently with the interests of justice in respect of the trial, be continued from day to day until its conclusion, unless the High Court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded. The statute makers wanted the High Court to record even a reason, even for one single day's adjournment. And then subsection 7, every election petition shall be tried as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months from the date on which the election petition is presented. Day to day, within 6 months, reason to be recorded, even if 1 day's adjournment is to be granted. This is a very, very peculiar feature that you find when it comes to election petitions. Now, as far as the procedure is concerned, it is said the procedure stipulated under the CPC and the Evidence Act shall be followed as nearly as possible. This is section 87. What is even more interesting is section 93 of the Representation of People's Act 1951. Notwithstanding anything in any enactment to the contrary, no document shall be inadmissible in evidence at the trial of an election petition on the ground that it is not duly stamped or registered. This is one major hurdle all trial court advocates face when the stamping and the registration of a document comes. Even this has been shut out, and they said the election, notwithstanding anything contained in any other enactment, no document should be inadmissible at the trial on the ground that it is not duly stamped or registered as required under law. And then if you go to sections 109 and 111, you will find that even for the withdrawal of a petition, special provisions have been created and the withdrawal has to be notified in the Gazette. Not a simple withdrawal by a voluntary act of the parties. Withdrawal has to be by a publication made in the Gazette. The High Court shall direct that the notice of withdrawal shall be published in the official Gazette and in such manner as it may be there. Appeal is provided from the High Court under section 116A directly to the Supreme Court of India. And this says if the Supreme Court, the appeal is to be filed within 30 days and the Supreme Court is directed to look into these. This is the legal backdrop or the legal structure on which all these cases are being filed. The question now is, has this been followed in letter or in spirit? Now, the three leading judgments on the subject which cemented the issue, one of which was referred to by Sri Guru Krishnakumar in the course of his introductory remark, is Ponuswamy, AAR 1952 Supreme Court, page 64. 52 Supreme Court, page 64. 6 judges were deciding the issue then, the nascent Supreme Court. Election was challenged under 226 of the Constitution of India, and the improper rejection of a nomination paper that Sri Guru Raj Kumar touched about. But the Supreme Court, 6 judges said, that being so, it will be a fair inference from the provisions of the Representation of the People's Act to state that the Act provides for only one remedy. That remedy being by an election petition to be presented after the election is over, and there is no remedy provided at any intermediate stage. Therefore, a 6-judge bench of the Supreme Court of India in 1952 itself very categorically and clearly laid down the law and said there is only one method to challenge an election, and that method is by an election petition after the election is over, and nothing at the intermediate stage. The next important judgment, of course, is the favorite of the lawyers of the High Court, Mohinder Singh Gill versus Chief Election Commissioner, 78-1 SEC 405, a bench of 5 judges of the Supreme Court of India, led by the great, the one and only V.R. Krishnaiyer. In the course of this judgment, Justice Krishnaiyer talks about there are a few fundamentals, finer administrative norms and jurisdictional limitations bearing upon elections. What are these fundamentals and what are these limitations? He also refers to Winston Churchill's famous quotation of the little man making a little mark in the little ballot and in the little booth. And then he says that the importance of an election is highlighted in paragraphs 15 to 18 of this judgment. In paragraph 15, the reason why I'm drawing your attention to these is the Representation of People's Act and the Constitution of India said only an election petition. They have given the timelines. Ponnuswamy said only an election petition. And the reason why these election petitions stand on a different footing has been explained by Justice Krishnaiyer in paragraphs 15, 16, and 19 of this judgment. An election dispute is not like an ordinary list between private parties. The entire electorate is vicariously, not inertly, before the court. We may call this species of collective litigation where judicial activism assures justice to the constituency, guardians to the purity of the system, and decides the right of the candidates. Therefore, it is essential that courts adjudicating election controversies must play a verily active role, conscious at every time that every decision rendered by the judge transcends private rights, defends the constituency and the democracy of the country. And then he also draws attention to Lord Denning's famous quote, which says that a judge should not be a mere mason, he should not be a mere carpenter, he should not be a mere mechanic, a working mason laying brick on brick. He should be an architect of law. I am consciously drawing your attention to these particular passages. Justice Krishnaiyer wanted judges to be verily active, conscious at all times that you are defending the constituency and the democracy itself. And he refers to Lord Denning and said you should be an active architect in the judgment and not merely a passive working mason laying brick upon brick. Ultimately, in paragraph 92, the Lordship concludes, for every wrong done during the election in progress, although it is postponed to the post-election stage and the procedure as predicated under Article 329 and the 1951 Act. He read both the 1951 Representation of People's Act and the Constitution of India and said it is the only remedy open is an election dispute raised by an election petition after the election is concluded. To the same effect is Justice Goswami's concurring judgment at page 123. If during the process of an election at an intermediate or a final stage, the entire poll has been wrongly cancelled, a fresh poll has been ordered, etc., that is a matter which may be agitated after the declaration of the result by questioning the election in an appropriate forum by means of an election petition in accordance with law. The appellants then will not be without a remedy to question every step in the election process and every order that has been passed in the process of the election, including the countermanding, can be challenged later. These two judgments, ladies and gentlemen, and the Constitution of India have set that in stone that the only way out is to challenge an election, whatever be the grievance, whatever be the cause, starting from the improper rejection of a nomination paper till the declaration of the result and the corrupt practices. The only way out is an election petition in the appropriate tribunal, which, as per law, is the High Court of the state. Now, later in 2008, Supreme Court cases 216, in the case of Ashok Kumar, despite these two judgments of Ponuswamy and Mohinder Singh Gill, the matter was again agitated and the power of the High Court under 226 was brought into issue. But after considering the case law on the subject, in this judgment of 3 judges also, it was said that it is only the election tribunal which can decide. But a note of caution was sounded to the tribunals which are dealing with the cases. And I am referring to para 28. Election disputes are not purely private civil disputes between parties. Though there is an individual or a few individuals arrayed as parties before the courts, the stakes of the constituency of the whole are on a trial. Whichever way the list terminates, it affects the fate of the constituency and the citizens generally. A conscientious approach without overriding consideration for welfare of the constituency and the strengthening of democracy is called for. If you remember what Justice Krishnakumar said, he said a proactive approach and not merely a working mason, you should be an architect. The next judgment says a conscientious approach, the overriding consideration for the welfare of the constituency and the strengthening of democracy. Although in effect you are deciding a list between 2 private parties. Then in paragraph 30, it said the provisions of the Constitution and the Act say that you should ignore the trifles, even if there are irregularities and illegalities, and knock on the doors of the court when the. Am I audible?
There is some.
Yes, something has come in.
Yes.
Now I'm audible. Now again it is said you should knock on the doors of the court only when the election proceedings in question are over. Therefore, we have the Constitution of India which says it shall only be tried. No other court shall try this election dispute. You have the Representation of People's India which says only the High Court should try the election dispute. You have 3 leading judgments of the Supreme Court which said only the courts can, which is the literal and the correct interpretation of the law. But at the same time, their lordships have also cautioned the courts that are dealing with these disputes that you are actually deciding a dispute which affects the constituency at large and also the democracy at large. Although technically it is a list between 2 parties, a winning party and the losing party. And what did they tell the judges to do? Be active, take a conscientious role, take a proactive role. This is the legal backdrop against which the cases are being dealt with today. My good friend Sri Vijay Raghavan from Chennai, when he saw the topic, he also sent me a small note on the subject. In that note, he points out that there are 5,300 election cases which are still pending as on date in January 2023. And the average life of a case, according to Mr. Vijay Raghavan, is 3 to 5 and sometimes even more than that, 7 to 10 years. You have 5,300 cases of this type which are still pending before the high courts of the country. The question is, and you should also remember one thing, the Act was amended by Act 47 of 1966, by which jurisdiction was conferred to the high courts of the country. If you look at the law as it progressed from 1966 to 2024, 34 years there and 24 years, 58 years have passed since the jurisdiction has been conferred exclusively on the high courts. The question now is, have they risen to the occasion? Have they actually rendered justice? Have they kept in mind the words of Justice Krishnakumar or the others? Did they adopt a conscientious approach? Did they take a proactive approach? That is why I said, when my friend Shyampadmanassociates said critique, he has made it a little more easier for me. If you look at the flow of law, you will be surprised. In fact, Justice Jasti Chalameshwar, in fact, I referred to that judgment in my introductory. He said it has become a mockery of the system. This is where we are going. The first judgment I would like to draw your attention to is reported is a judgment of 1964. This is an old journal called, I think, Election Law Report, 1960, 26, Election Law Report 146. And the citation, the names are Dr. Sushila Balaraj versus Ardhendu Bhushan. It is available on the SCC online also. SCC. The matter was being decided in 1964. The election was of the year 1952. 1952 election, 1964. The term had already expired, beyond doubt. And in paragraph 8, I'm sorry, it is necessary to bear in mind the scheme of the Act that election petitions must be tried expeditiously. If these petitions are allowed to be conducted in a leisurely manner and go on interminably, the very object of permitting the remedy of challenging the validity of the election in good time would be defeated. That is why Section 90 requires that every election petition shall be tried as expeditiously as possible. Endeavor shall be made to conclude the trial within 6 months. Dealing with election appeals filed in this court, the same principle applies. 4 judges of the Supreme Court in 1964 cautioned the tribunals, you have to dispose of the case within 6 months, and the appellate tribunal, which is the Supreme Court of India, also has to dispose the case within 6 months. This is 1964. In 1974, 4 Supreme Court cases, 237. 74, 4 Supreme Court cases, 237. Paragraph 13. Keeping the proper functioning of democracy, the principal object of the Representation of People's Act is the purity of election. When an election of a returned candidate is challenged, the trial is sought to be enforced, making all safeguards against the delay. Trial has to be necessarily expedited to rid the candidate as well as the constituency interested in the result of the election of any taint, suspicion of a corrupt practice which are enumerated under the Act. The trial needs to be continued from day to day until its conclusion, unless the High Court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded. The very object of an expeditious trial will be defeated if the presentation of the petition would be treated casually and lightly, permitting all kinds of devices. 64 to 74. We are still in the same situation. The next judgment is AAR 1987 Supreme Court, page 1577. AAR 1987 Supreme Court, page 1577. In 1987, the Honorable Supreme Court was dealing with an election of 1981. The term expired in 1984 when this Lok Sabha was dissolved, and thereafter another election was held. Still they were deciding the matter and said, before we consider the submissions on merit, we would like to say that the Parliament should consider the desirability of amending the law to prescribe time limits for an inquiry into the allegations of corrupt practice, or devise means to ensure that the valuable time of the court is not consumed in election matters, which by a flux of time are reduced to mere academic interest. And they said there should be a time limit. Public interest is primary. 1966, 1974, and 1987. And then 2015, volume 16, Supreme Court cases 149. This was an election of the year 2012. In 2015, the Honorable Supreme Court was 10 miscellaneous petitions were filed by the successful candidate who was the respondent from 2012 to 2015. He successfully ensured that the trial did not even start. 10 miscellaneous applications were on the record of the court. The matter reached the Supreme Court because of an adjournment application. And the Supreme Court was dealing with the matter. After considering the case, they have considered at least 4 judgments of the Honorable Supreme Court before finally saying in paragraph 15 engrafting a provision in the nature of section 86(7) of the Act, the legislative intent is clear that the court has to endeavor to dispose of an election petition as expeditiously as possible, not to allow the parties to take resort to unnecessary adjournments or to file vexatious applications. This kind of an attitude has to be curbed from all angles because the law does not countenance it. What is even more surprising is the penultimate paragraph. In 2015, for a 2012 application, the Supreme Court noticed the High Court has not even framed the issues. It shall frame the issues. Thereafter, the evidence shall commence, and the court, having regard to the statutory command and the norms in democratic polity, dispose of the election petition by the end of 2016. Just imagine the fate of the candidate, of the petitioner who was challenging an election on whatever be the grounds. 3 years have elapsed. Even an issue has not been framed. Issues have not been framed. Scheme of the Act is 6 months, day-to-day trial, keep the purity of the election, keep the interest of the constituency and of democracy at large in mind when you're dealing with this. The next judgment is even more shocking, and the directions are really troubling. 2001, I'm going back in time. I just wanted to clear the pitch before I said this. 2001, 2 Supreme Court cases, 652. 2001, 2 Supreme Court cases, 652. This was dealing with a 1996 election. This case, a 1996 election, 2001, the Honorable Supreme Court was given. And for the sake of record, for the sake of continuity, directions were issued of framing issues and recording them. CPC came in 1908, Evidence Act in 1872. Both these enactment deals with framing of issues and recording of evidence, etc. The Supreme Court, I don't know, I really pity the. I don't want to say anything more. I'll just draw your attention to paragraph 17. There are a few aspects of this case which have caused us concern, and before parting with the case, we would like to place on record our views in this regard. The manner in which the election petition has been tried defeats the very purpose of entrusting the jurisdiction to try an election petition to the High Court by the Representation of People Amendment Act of 1966. 1966 Amendment, 2001, the Honorable Supreme Court was dealing with the case. 35 years had elapsed since the amendment conferring exclusive jurisdiction on the High Courts to try these matters. And this is what the Supreme Court had to state. Out of the several issues, we propose to deal with 2 aspects: framing of issues and recording of evidence. An election petition is like a civil trial. The stage of framing of issues is thus an important aspect. Each of the corrupt practices alleged by the petitioner, denied by the defendant, should have formed the subject matter of a distinct issue of sufficiently expressive of the material proposition of fact and law arising from the pleadings. This is how issues are framed on a daily basis in every trial court throughout the country. Yet a note of caution had to be sounded by the Honorable Supreme Court 35 years after the amendment. Please frame an issue on the basis of the pleadings with sufficient clarity. The next, now as to the recording of evidence. The recording of the evidence shows the statements of the witnesses are recorded not in the narrative form, but in the question-answer form. During the course of the appeal, we asked the learned counsel about this feature. We were said that such a practice is prevalent on the original side of this High Court. The witnesses are named, but not numbered. Witnesses are named, not numbered. Some of the witnesses are asked a few preliminary questions, the relevance whereof we have not been able to appreciate. Many of the witnesses have been asked whether he was appearing in court on a subpoena and then asked to produce the subpoena in the court for the perusal of the presiding judge. I mean, whether he has been summoned or he has appeared by himself. A host of such questions have been asked both in examination in chief and in cross-examination, as are not permitted under the provisions of the Evidence Act. To wit, witnesses have been confronted with contents of the election petition or the written statement and asked to make comments or offer an explanation on the passages. How can a witness be confronted and asked to explain the contents of the averments made in writing or a document to which he is not a party? Statements of 18 witnesses have been placed before us in 18 volumes, some of which run into hundreds of pages each. We are told 120 days were consumed in the recording of evidence. 120 days of evidence of witnesses who are merely named, not even numbered, in a case where issues were not even properly framed, leading the Honorable Supreme Court to comment as to how issues are to be framed. Witnesses were asked to comment upon the contents of the election petition and offer their remarks on the same. This must have pained their lordships a lot, otherwise I'm sure they wouldn't have penned it down. The question I'm asking myself and I'm asking this august audience is, an amendment took place in 1966 and in 2001, these sort of directions had to be issued. The question is, are the judges really keeping in mind the mandate of the law under 329 of the Constitution, under the Representation of People's Act? It said 6 months day-to-day trial. Or did they look into the Constitution bench judgment and say, take a proactive role, be a conscientious judge, be an architect, don't be a mere mason or a bricklayer? Can 120, just a minute, 18 volumes and 120 days of recording of evidence reflect the earlier comments of the Supreme Court? Are they taking it seriously? Are they taking it in the true spirit? Is the question that has been troubling me since long. A trial court judge, a trial court advocate worth his salt would definitely appreciate the pain and anguish that the Honorable Supreme Court is expressing. How to record evidence? Is it necessary to be told by the Honorable Supreme Court of India more than 100 years after the Evidence Act has been enacted? And what are they dealing with? Election disputes, where the Supreme Court said this affects not merely you or the constituency, it affects democracy at large. And these sort of directions have to be issued. The next judgment is 2009, 13 Supreme Court cases, page 131. 2009, 13 Supreme Court cases, page 131. In this case, the Supreme Court in paragraph 48 cautioned, in an election petition, the High Court acts as a court of original jurisdiction and the election petition is a civil trial and the jurisdiction in such a trial, stricto sensu, cannot be said to be appellate in nature. Clearly, the High Court acted illegally in treating its power only as an appellate authority and not as an original authority, for it proceeded to try and determine as to whether or not the decision-making process is legal. That approach of the Honorable High Court, in our considered opinion, was illegal and unjustified. I think all of us will accept normal, in a 226, one of the first things that is read, the decision-making process is what we are challenging. And in this case, despite the 3 judgments that we had cited earlier, again it was questioned and the High Court accepted it. They went into the decision-making process to see whether it is correct or not, instead of trying it like an original petition and holding a trial. The High Court was duty-bound on merits by framing issues and thereafter for production of evidence in support of their respective cases. The High Court, despite being the court of original jurisdiction, acted as a court of appellate jurisdiction and dismissed the petition without allowing the parties to produce evidence in support of their contentions. as the matter was not adjudicated on merits, we set aside the judgment and order passed by the High Court and remit the matter to the High Court to proceed in accordance with law, and the dispute should be disposed of within 6 months. This is a May 2009 judgment dealing with an amendment of 1966, which told them that you are giving the exclusive power to dispose of these matters within 6 months. And the judgment, next judgment is 2013 14 Supreme Court cases 685. Since all of you are active practitioners and judges are also there, I'm sure you'll appreciate the disquieting factors which the Honorable Supreme Court noticed. Though fresh elections have since been held in the state of Tamil Nadu, and to an extent this appeal has become infructuous, the manner in which the election petition was dealt with by the High Court causes us concern and necessitates making reference to some salient features. The salient features, I am giving you a few dates. Election petition was filed on 24/6/1966. I'm sorry, 1996. 24/6/1996. Trial went on till February 98, 2 years. Judgment was reserved. The judgment remained pending in the High Court for 20 months. Judgment reserved in February 98, pending for 20 months. After the judgment was pronounced on 29/12/99, 22 months after the judgment was reserved. And to add injury, the certified copy was delivered after another 30 months. 53 months was lost in this case in the High Court. "53 months had expired. The total term of a legislative assembly would be 60 months or 5 years. 5 years? 5 into 12, 60 months. 53 months were lost in the first court, which is the original court, that is the High Court, of which 20 months were lost in the pronouncement of the judgment, and the rest was lost in the delivery of the certified copy. We are at a loss to understand why the election petition was dealt with so casually in this case. That is the reason why the Honorable Supreme Court still went on to. You have 2 or 3 judgments that I brought to your notice. The Honorable Supreme Court had to comment how evidence is to be taken, how issues are to be framed, what is the promptitude and the speed that is necessary to be disposed of. Despite, and normally it is said the matter has become academic, please don't pronounce. Despite the matter becoming academic, they have taken it up and given directions. And the judgment which I said, which prompted this whole topic, is 2015, volume 14, SCC 519, 2015, volume 14, SCC page 519, Muhammad Akbar versus Ashok Sahu, where Justice Jasti Chalameshwar is dealing with. Para 12. No, I'll also read what is Lordship's opinion. It was the pious hope of Parliament that election disputes under the Representation of People's Act 1951 should be resolved expeditiously. The purpose is obvious. The tenure of the members of Parliament as well as the legislature is relatively short. It is 5 years in case of Lok Sabha and Legislative Assembly, 6 years in the case of Rajya Sabha, etc. Therefore, if a dispute regarding the election of a member of any one of the said bodies, it is desirable that the dispute be resolved as early as possible for various reasons. However, we are sad to state that invariably the resolution of the election disputes in this country takes unacceptably long periods in most of the cases. Very rarely an election dispute gets resolved during the tenure of the declared candidate, reducing the adjudicatory process into a mockery of justice. Such a delay, coupled with the right of appeal to this court, makes the whole process of adjudication a task in a good number of cases. The reasons are many. When we come to the conclusion, we'll again deal with this judgment. Lordship noticed that it has become a mockery of justice when the election disputes are not disposed of within the said 5 years and the appeal which is provided. The last judgment that I'd like to draw your attention is 2021 SCC Online. 2021 SCC Online SC, page 538, only for a very limited purpose. In this case, this relates to an election in Karnataka. The election was held in 2012. 2008 election, 2012 election petition. The order was passed in the election petition on 1/6/2012. 1/6/2012, the election petition was disposed of. The matter, Supreme Court, immediately an appeal was filed before the Supreme Court. Supreme Court ordered interim stay and notice on 11/6/2012. 11/6/2012. The matter was finally decided in 2021, August. Election of 2008, disposed of in 2012, interim stay in 2012, final decision in 2021. Only for this limited purpose. I mean, other things in the case are very relevant. The reason why I'm drawing your attention to these is, in my opinion, you may agree with it, you may not agree with it. Justice Jasti Chalameshwar's comment that it has become a mockery does not seem to be far from the truth. 66 to 2021, exclusive jurisdiction has been given to the High Courts as the original courts. They, in my opinion, have not risen to the occasion and dealt with these cases in the manner in which they were to be dealt. There are various factors which are coming in the way of the judges disposing. I'm not for a moment saying that they have failed totally. The system has failed according to me. There have to be some remarkable and quick amendments to the whole process. If the idea of our Constitution fathers, of the founders, and the Constitution benches that we have referred to are actually achieved in reality, the letter and spirit of the law can only be done if these matters are taken up with the promptitude. Why is it that, in fact, Justice Chalameshwar himself, in the course of his judgment in 2015, says that he gives a few suggestions. He also notices the fact that returned candidates leave no stone unturned for protracting their elections. He also says the law of elections and election disputes is highly technical. There is always a scope for a lot of objection and cross-objection regarding every step in the conduct of the election process. The absence of dedicated benches in the High Court for resolution of the election disputes is another factor which is contributing. And therefore, he deemed it desirable he gave a direction by saying, we deem it desirable that in each High Court, benches are to be created by the Honorable Chief Justice to deal with election petitions exclusively. In other words, those judges who are assigned with the work of adjudication of election disputes preferably may not be burdened with any other work until the adjudication of the election petition is completed. This exercise may not be difficult, especially the class of litigation occurs only once in 5 or 6 years, and the number of cases would be limited. We are conscious of the fact that it is not possible for laying down any absolute rule in this regard. Essentially, it is for a Chief Justice of the High Court to run the administration and devise ways and means of expeditiously disposing the cases brought before the High Court. We only gently remind that this kind of delay in the adjudication of election disputes exposes the High Court to unpleasant criticism, damaging the credibility of the institution, a situation which has to be avoided at any cost. Therefore, gentlemen, ladies and gentlemen, we have a situation. 1966 to 2021, it has been noticed by the highest courts of the land that the trial of these cases is not proceeding in the manner that it is meant to proceed. The question is, what needs to be done? As Justice Chalmesh has said, there is a need for exclusive election dispute benches. And he is right in a way in saying that this class of litigation arises once in 5 years or 6 years, whether it's an assembly or a council or Rajya Sabha, Lok Sabha election. These are not election disputes which flood the courts with litigation. Therefore, one of the primary things is exclusive election benches to try the dispute and ensuring that the judge trying the dispute is not given any other work from his or any other subject in the roster. The whole idea seems to be that a corrupt practice has occurred or something else has happened, incorrect nomination. A person who is not qualified to hold the post is ultimately ending up holding up the post because of the delay. At the end of 6 years or 5 years, it is argued that the case has become, list has become infructuous. There is no need to pronounce on the merits of the matter. It may be a case where a person who is not at all eligible holds a constitutional post or a high post of this nature, and then at the end of the day, he gets away scot-free. After going through the case law, I felt a few of these things. I can only make suggestions. I cannot do anything more than that. I adopt what justice. This is one of the ideas behind a gathering like this. People should apply their mind, because in my opinion, the machinery that has been created has failed. It has not been able to achieve the target. Various reasons are there. It is noticed that successful candidates delayed. Application after application is filed. No doubt about it. In one case, it is noticed in a span of 2 years, 10 applications. Their lordships have recorded it. The successful candidate would definitely like to stall the election. But then I do feel that a judge has the power to control this. It is not as if the judge controlling the trial is powerless. When procrastination and delay, tactics to delay the trial are done on a daily basis in the trial courts. Judges know how to handle it. But when it comes to the High Court, one aspect which I would like to bring to this August group's knowledge is the fact that many of the High Court judges who have practiced essentially on the High Court side are at a slight disadvantage when it comes to conducting a trial proper. That is a major handicap that they will face. Because their entire legal upbringing, legal training is on the basis of papers, is on the basis of arguments, is on the basis of documents. The nitty-gritties of a trial, the difficulties of a trial, the tactics of a trial court advocate who can successfully stall the case without appearing to stall the case. These are all things which only trial court judges are very, very good at. The question is, in every High Court, we have High Court judges from the district judiciary who are elevated, who can very, very easily handle this trial. So one suggestion in continuation with 2015 Supreme Court, creation of exclusive benches, which will try these cases, preferably headed by district judges who are elevated to the High Court, who have more than a working knowledge and who are hands-on either in framing issues, conducting a trial, recording of evidence, or in dealing with these miscellaneous interlocutory applications. That is something they do on a daily basis. They can easily handle a trial. I conducted a trial in the course of before I debited my own. I knew, despite telling the learned counsel, please don't ask that question. He felt I was actually interrupting. It was a question which is not really necessary in the scheme of things. And then I had to tell him that there is a time-bound 6-month period within which we had to dispose of this case. And the next assembly was, the election notification was also being issued. We were in the council was in a hurry, therefore I had to take them. Therefore, I had to caution him that these are not really necessary, although he didn't like it. That is when I realized that if it is a trial court lawyer, he would have immediately caught on. It is something that is already there in the pleading or in the course of his chief affidavit. Why does the need to repeat it in the cross-examination? And an admission made in the course of pleading, as all of you know, has a greater value than an ordinary admission. These sort of things, did you write this in the written statement? Did you state this in paragraph 4 of the written statement? Or in the, these are not really necessary. Therefore, I would say dedicated HC benches once in 5 years, exclusively to deal with these cases, some amount of training to the learned judges of the High Court on conducting a trial, or asking the district judges who are elevated to the High Court to essentially conduct the trial, and then supplying them with sort of a manual or a volume of case law. Enough judgments are there if you look into the pronounced judgment. Not more than one adjournment should be given. Supreme Court has already said it. No liberal dates. Supreme Court has already said. Decide all the miscellaneous applications at one date. All of these are matters which are touched with in this Honorable Supreme Court. So if the council makes an objection and tries to stall, there is enough case law that is already available, which can be given to the learned judge to note it in his order. In view of the judgment dated so and so, recorded in so and so, so and so, no further adjournments are possible. In view of the judgment of Justice Deepak Mishra and so, all the miscellaneous applications will be heard on one day. All these practices of stalling, of asking for dates, the Supreme Court also said, don't give dates liberally. We ourselves have looked into starting from 64 Supreme Court till date. More than 4 to 5 times the Supreme Court said no liberal. The judge can quote it and say. If the lawyers are seeking time, I'm not really saying lawyers, if the returned candidate who wants to stall is seeking time, mechanisms are there, law is there, it should be enforced. Therefore, if a manual of the case law is given, or a handbook is prepared and given to the learned judge of the High Court who is actually dealing with this case, telling him this is the law on the subject. These are the cases which will come to your aid in case of any tactics are adopted by the learned counsels, by the returned candidate. You can stall it. This should be done. And then, therefore, I mean, I don't know if Mr. Vijay Raghavan is there. He's also got some views. Mr. Raghavan, I don't know if you are there. Technology should also be. Is he there, Mr. Shyam?
No, sir.
Okay.
But he had called me.
That's okay. That's understand. Therefore, even a leveraging of technology. You can hold, video conferencing to record evidence. If the judge has other subjects on his roster, and there is a time frame within which these cases have to be disposed of, let there be video conferencing. Let advocate commissioners be appointed to record the witness. Demeanor of a witness is something everybody quotes. I don't know, Mr. Justice Ramakrishnan, and how many times did demeanor of a witness actually influence a judgment, sir? I don't think it. Once in a while it happens. I'm not saying no. But in a larger perspective, when there is a 6-month embargo within which the case has to be disposed of, time and again the Supreme Court is saying, do it quickly. You can't allow these things to slip. You cannot ask your advocate commissioner to record the evidence. Get the evidence if you're busy otherwise with other subjects on your roster. These are all things that, apart from a drastic amendment of the procedures. And that is not within my province, but I feel that there should be. Justice Jalamesh, in the course of his judgment, himself says the law is too technical in this. Objections are raised on every point. These should be avoided. According to me, ladies and gentlemen, in conclusion, the word critique used by my good friend Yul Brynner Shyampadmanassociates has really helped me in concentrating on this subject. I personally feel Justice Jalamesh was not wrong in stating it has become a mockery of justice. The system has to be reinvented. The wheel has to be reinvented now. An embargo of 6 months is rarely, if ever, followed. Day-to-day adjournments, virtually zero complaints. Despite the Supreme Court telling us in so many words, please do it, I think the system has not risen to the occasion. It is time that a good body like this, intellectuals like you, should make the suggestions wherever the opportunity comes in the course of your careers, or maybe when Justice Vijay is writing a good judgment or Shyam is arguing a good point, wherever it happens, look into these aspects because they are virtually allowing corrupt practices, etc., to go unchecked. People without a right to contest an election, whereas nomination should have been rejected, are allowed to hold the post for the full term. People who indulge in corrupt practices are allowed to continue their full term. Therefore, I would say this in conclusion, dedicated election benches, dedicated election judges, time-bound trials, a training to everybody concerned in the field. In fact, in the High Court, we also had a difficulty. Some Mr. Satyarao and other district judges are also Ramakrishnan sir. We did not have a stenographer who could actually record the evidence in the proper form. We had to send word to the neighboring district, get a typist, steno who was experienced, bring it to the. Suddenly you start to talk of oath and all the people were looking here and there. It happened, but because our High Court was close to a district court, we could immediately access a stenographer who was very good, immediately bring him, make him sit. He knew how to, because the court officer did not know how to mark a document. How the appendix of evidence is to be read, because these are all crucial things. If these are not properly done, the entire trial can be vitiated. All of these were done in court with the assistance of somebody from the district bench. Therefore, I would say dedicated election benches, training to everybody concerned, including the staff. Maybe an election manual of case law to the judges to enable them to rely on this case law and to defeat or to delay procrastination or stalling tactics by candidate. And last but not the least, a drastic overhaul of the law. This, ladies and gentlemen, is my critique, as my friend Shyam wanted it. Thank you.
Thank you, sir. The consequences and the repercussions and the importance of the subject could not have been more emphasized. With all the restrictions and without making any comment on the subject as such, may I request Justice Vijay to just offer his comments.
There's nothing much for me. I'm new to this and I've not done any election petitions, but I always had this notion that the most of these petitioners who are filing these election petitions rarely have see the end of the litigation. So many a time they are delayed for various reasons, for as His Lordship has put it, for very technical reasons and interlocutory against interlocutory orders, people approaching the higher forums, Supreme Court, getting things delayed. But I'm new to this. Let me figure out a solution to all these issues, because one thing is that if there are 5,300 cases which are pending in various high courts, as the figure is right, it's a matter of serious concern as to the efficacy of this particular manner of adjudication. The second aspect is the high court judges are not very well equipped to understand the conduct of trial. I mean, those who have practiced only in exclusively in high court are not as expert, do not have as much expertise as people who have done the trial work. So there is a hitch in this issue, but then everything is a learning process. We can't say we don't know. We have to learn, we have to equip ourselves, we need to move on. Some serious issues which have been pointed out, I can't go anything beyond that, considering the reversal of roles.
Thank you. Thank you, Justice Vijay. And but the learning process, the collateral damage, can the system sustain? I'm not very sure, because it has been, like Justice Somayajulu sir said, 30, 40 years and still we are nowhere. The lack of exposure to the trial side, requiring the Supreme Court to remind how to frame charges and how to have the chief cross and re-examination. Maybe have the comments of Justice Ramushan sir on the topic.
Thank you very much. After a long time, we are seeing the erudite judge and a lawyer. Now a lawyer, Somayajulu. I really agree with Somayajulu on that. See, not only the election petition, in almost all cases where the time constraint has been provided or limitation of time has been provided for disposal of cases, never disposed of within those times. Take for example, Rent Control Act. Take for example, your NA Act. All cases, wherever it is. So the time constraint that has been provided in the Act for so many reasons. If it comes to the trial court, probably because of the number of cases that is being pending, all those things will be when it comes to the High Court, that is not the speech. Because election petitions, how many petitions are being filed in the High Court after the election is over? Maximum 5 or 6.
Yes.
Not more than that. One. Secondly, as rightly said, the lack of knowledge on the trial side as to how the trial will have to be conducted is playing a great role in deciding the election disputes also. So for example, rejection of a nomination or acceptance or non-acceptance, or a person who is disqualified to be a candidate is being elected or is being contested. All those cases can be disposed of even without evidence. See, all admitted facts will be there because whether you are holding an office of double profit, etc., whether you are qualified or not, whether the nomination papers have been properly done or not, etc., all those things can be decided. That depends upon the trial court experience of a lawyer, of a judge. Trial experience of a judge will decide whether this requires an evidence or not evidence. In certain cases where lack of pleading in an election petition, which itself is a ground for rejection of the application.
Yes.
In how many cases that is being taken up as a preliminary point and then being decided? See, these are all the areas where you will have to exercise or discretion as to how you can split up the cases of election disputes. As I cannot agree with Somayajulu as regards exclusive jurisdiction being given without assigning cases, because the number of cases are 1 or 2. When 5 judges have been deputed with that work, then if the case is for the purpose of pleading or for the purpose of this thing, case is posted, he may not be having other work. So you will have to go and sit. The trial court, it will be possible because you have got number of cases.
Maybe from the stage of trial.
Evidence. Then after framing of issues and it is posted evidence, you can spend your time for deciding the election petition exclusively. And day-to-day trial can be possible. I mean, that is being done in most of the high courts. In Kerala High Court, it is being done only in cases where, because even when we are sending summons, we are selecting number of witnesses that can be examined on a particular day, depending upon the nature of evidence to be given by the witness. So if that is being selected and summons are being issued on day-to-day basis and you are posting it, depending upon the available witnesses, the trial can be possible. Cases where now the technology can be used, suppose the witnesses are in abroad, the video conferencing, whether record can be, the evidence can be recorded in a video conference itself is a dispute till the Supreme Court came to the rescue. In one case, it found no, it cannot be possible by a family court. Subsequently, later when the technology was introduced and they felt that the technology is also required for the purpose of speedy disposal, now it is being done. So that hurdle was there earlier. Now it has been cleared. Now it can be possible, the technology can be used. As regards the other, how many district judiciary elected members, promoted persons as high court judges being welcomed by the high court lawyers when they are strict in disposing the cases? Because then they will say that you are still a district judge. You have not grown up as a high court judge. So these are all the hurdles that the judges are also facing when it comes. But that is not a ground. I don't say that it is a ground for postponing the election disputes. Election disputes will not be disposed of. In most of the cases where you are upholding the election, question is not going to affect. But if you are disqualifying a person and that person is being holding the position and getting the public money, can it be paid back? No. There is no provision for taking back the money this is paid. It is not there. And the illegal corrupt practices, how far the evidence can be collected for those things. So these are all the areas where the law must be made clear as to how the corrupt practices can be defined. Each and every aspect will not be mentioned, so that the nature of evidence to be adduced on those aspects can be restricted. Otherwise, corrupt practice by an agent with a knowledge, connivance, etc., loose words are being used. How the trial judge will be able to come to a conclusion on the basis of the evidence available, how far the evidence can be stretched for the purpose of considering the question as whether it has been done with the connivance of the party or not. As regards the election expenses is concerned, that election expenses question will be decided by election commissioner first. Only if that is being decided, that is been properly done or not, that can happen only after the election is over and the time has been provided for him to produce the accounts. They will have to verify all those things. So those things are all aspects where the election commission will be power to disqualify a person if the accounts have not been properly filed. That is also not being done. So all these cases, I feel that proactive steps will have to be taken by the legislature also by, or you will have to go back to the original position of election tribunals will have to be constituted. A number of election tribunals. Now the Supreme Court has said Number of special courts will have to be established for the purpose of deciding the matters, criminal matters relating to the elected representatives. Because if it is being convicted, he will be disqualified. Suppose his conviction is after the period is over, no consequence. So all these things will have to be taken note of cumulatively, and effective steps will have to be taken by the judges also. They will have to take, as Krishna has said, proactive judges dealing with the trial matters and having experience in the trial side will not be provided with such type of work so that things can be properly done. Otherwise, the Supreme Court will have to remind again and again, frame the issue. What are all the things to be considered for the purpose of framing issue? Even the election petitions, I don't know how many lawyers will be there. Even the pleadings are not proper because the lawyers who are preparing the election petitions are High Court lawyers. Having only few will be having the knowledge of preparing a pleading. If it is not there, the ultimate thing is that the application will be suffer. But for that also, the judge who is deciding it must understand whether the necessary pleadings are there for the purpose of supporting prima facie to proceed with the matter. So all these things will have to be looked into, as it's really a concern dealing with election matters. Things will have to be done because we can only suggest. Vijay is very, when he was earlier appearing, he was very energetic. Now slowly
The burden of his office.
the restrictions will be there.
Shackles and the restrictions is weighing him down.
No, that is it. Even when wherever the necessity is there, they will have
I was
to.
just wondering whether I spoke right or not, whether it spoke anything beyond my purview.
No, I fully concede with you because we are now out. Even then, we got our own restrictions when, because the Somayajulu can go beyond because he is a lawyer now.
Mr. Guru Krishnakumar there, sir?
Huh?
Guru Krishnakumar, sir, is he there?
Yeah, he is very much here.
So the lawyers.
There is, sorry to interrupt Justice Ramakrishnan. On this delay, I didn't want to speak anything for only one reason. I would have necessarily had to comment on the expertise that is available in the High Court from the side of the bench, which is one of the reasons why I specifically refrained from speaking on it. Just once Justice Ramakrishnan finished, maybe a couple of sentences on that.
Sure, sir.
I also have a question for you.
So what I say is, as rightly pointed out by Somayajulu, Brother Somayajulu, you will have to have a strategy by the Chief Justice when selecting the judges who are expected to deal with the election matters. Necessary infrastructure, because as I had an occasion to deal with it for some period, because though I was in the High Court only for a shorter period, I had to deal with election petition. The staff does not know as to how the documents will have to be marked, how the sealing will have to be. Even the seal will have to be prepared on the basis of the trial court knowledge as a lawyer and also as a district judge. How that seal will have to be, how it will have to be marked. Suppose it is on consent, how it can be done. These are all the areas where the training must be given not only to the person, but the staff, or the judge who is deciding it, but also to the staff who is dealing with the matters. As regards the recording of evidence is concerned, we can train the stenographer. There is no difficulty because it can go as a running matter. Only if he goes to the question answer. As regards the commission is concerned, I have got my own reservation about the amendment to the CPC by recording, because the lawyers are also facing a lot of difficulties. When the disputability of the document arises, he may not be able to decide it.
That is okay.
You will have to put it there. And again, it will not come to the judge when you are accepting the evidence recorded by the commissioner. And if he found that the nature of recording and the question answer, I think probably maybe due to the insistence by the lawyer that it must go as a question answer. Another thing, as regards the evidence, recording of evidence, when there is a recording of chief evidence, chief examination, cross-examination is where the lawyers were careful in putting the chief examination to the witness. Now what happens is you are filing a chief affidavit. It is only a reproduction of the pleading from third person to the first person, nothing more. So the person who is cross-examining the witness will be more bound to go through each and everything. Otherwise, there will be comment. That aspect has not been challenged at all in cross-examination. How can you blame the lawyer for putting a lot of questions on the...
You remember that in one of the cases in Calicut, even in the chief examination, the witness was not able to say, and finally the judge asked, is there any objection for you to dismiss the case? So because of the affidavit, it's being saved. Even at times in chief examination itself, the entire case goes at times earlier.
So these are all the things where will have gone into by the legislature, and also the admissibility of evidence on certain aspects will have be made as an admissible one. And the Evidence Act, as in the case of family court, to certain provisions of the Evidence Act will have be taken away. So the courts will be given the discretion to accept certain evidence even without adducing evidence on certain aspects. So these are all the areas where I do not know whether how far the new Evidence Act is going to help us on those aspects. Let us see on that. Thank you very much.
Thank you, Raman sir. Can we come to Krishnakumar sir?
Yeah. Krishnakumar, one question.
Yes.
Practice, you see, in 2021, we noted interim stay granted in 2012, matter being heard in 2021.
Right.
Interim stay notice. That shouldn't there also the court post the matter, or shouldn't the councils make it a point to ask? The overall period is 6 months. Therefore, please post the matter. I mean, can that be done?
Oh, see, Mr.
No,
Somayajulu,
it can be done. It can be done.
one
doubt
thing
about it.
One thing is there, because suppose in a case where an interim application has been dismissed,
Yes.
if it goes to the Supreme Court say you can, because when it comes to the High Court under Article 227, you are saying that can be considered at the time when you are filing an appeal after the evidence is over, unless that application goes to the root of the matter and decide the issue itself.
Correct.
If it is not there, why should unnecessarily be prolonged by granting a stay of the trial process?
That's correct. That's right. That's right.
In that way, the Supreme Court also can filter the nature of cases that can be taken on an interlocutory orders that is coming in an election matter.
That's right. No, there's just one thing. In fact, perhaps that will also be some kind of a response to what fell from Mr. Somayajulu. Now, what happens is bulk of the matters which come to the Supreme Court at the interim stage or Order 7, Rule 11 petitions. What happens is a returned candidate, because the election process, the election petition adjudication process is so technical, is, I think, rightfully entitled to raise a question that the petition is lacking in particulars. Let's take a case of corrupt practice. Now, absolutely no particulars are given. A petition is filed saying he and his election agent are guilty of corrupt practice. What is the case that he's supposed to then confront? What is the case that he's supposed to answer at the trial? Therefore, he comes to the court and says, now this is a case which ought to be rejected at the outset.
Well, that's the reason why I said, Mr. Krishnakumar,
yes,
that if we can segregate the cases where it can be decided on preliminary issue itself and regarding the maintainability, because section 900 itself says about it. Maintainability can be on what grounds you can reject it.
That's right.
So that can be selected by the judge. Then it is an ultimate decision on the election petition. You can file an appeal.
Correct. But then I entirely agree that a matter where notice and stay is given in 2012 and gets to be decided in 21, it's a strict no. Obviously, there is no standard by which this can be justified. I agree with Mr. Somayajulu on that. There's no doubt about that. But two other things I wanted to highlight. Now, many of these important aspects that you highlighted in the course of your presentation, many of them have been discussed in the 255th report of the Law Commission. Justice A.P. Shah's headed body has looked at many of these points and made various suggestions. In fact, they have said 86.7 has to be made mandatory. 86.7 today is only in the nature of a recommendatory provision. Now, they are saying it should be made mandatory. Like that, various other things have been said. One other aspect is there. Any petition on the ground of corrupt practice, the fact that a 5-year term may have gotten over will not render the petition ipso jure infructuous, for the simple reason of finding on corrupt practice will disqualify the candidate for the future.
Yes,
in fact, there are 2 reported decisions of the Supreme Court on this itself, how they don't become infructuous.
I did it, sir. In the course of my tenure, when the term expired, but I found it that he did not disclose the assets as warranted under the law.
Right.
So the criminal case was not disclosed, sorry.
Correct.
When he is disqualified, I wrote it should be forwarded to the appropriate authorities to disqualify him for the future.
That's right. That's right. In fact, only one thing on a personal note, the number of Order 7, Rule 11 matters in election petitions that I have done in Supreme Court are triple the number of final hearing appeals in election matters. This is one of the sad realities we have to reckon with. It could be either from the side of the election petitioner itself or the successful candidate. But either way, these matters get taken up right up to Supreme Court because the stakes are so high for the returned candidate.
Okay. Thank you, sir.
Thank you.
Thank you.
Thank you very much. As we come to the end of our 286 session, what this platform is all about is not finding answers or offering solutions, but making us think, dwell deep into, and come up with something or something concrete contribution to the legal or justice dispensation machinery. Today, well complemented, both Somayajulu sir and Guru Krishnakumar sir, both senior lawyers of the Supreme Court. And we are thankful for the valuable presence of Justice Ramkumar sir, Ramakrishnan sir, Vijay sir, and all of you wonderful participants. I hope the purpose of this session would be served if each and every one of you take upon ourselves, each and every one of us take upon ourselves the responsibility of contributing constructively how to make these things, appreciating the consequences and the depth at which this affects our very existence as a democracy. So once that is done, we feel that today's evening is time well spent, and even otherwise, it was thought-provoking. Thank you very much. Thank you very much, all of you. Till we meet again next time.
Thank you. Thank you.
Thank you. Good night.
Good night.
Yes.